Hi. Hi, how are you?
Hi.
Good afternoon, everyone.
Afternoon.
This is Professor Holly Gregory, and we'll begin around 2:30 for people to come into the Zoom. I have Judge Holly Gregory here with me, and we'll be doing a Q&A towards the end of the presentation with the judge regarding several questions I have to ask her about the processes regarding a civil lawsuit or a civil claim in civil court. So we're gonna wait a little bit until 2:30, and then I'll begin the presentation. I hope this will be an informative session for all of you, an educational session also, and I look forward to it.
Uh-oh, here we go. He got it on here.
All right, without further ado, I do want to begin the presentation. I have a lot to discuss in a limited amount of time. This will only be for about a half hour. So I want to begin now. And towards the end, we'll have a Q&A session with the judge to answer some commonly asked and frequently asked questions regarding these type of cases. So with that being said, I would like to begin the presentation. So know your rights. This is very important, and I think it's especially important during these current times with the pandemic, COVID-19, with the numerous cases such as the Breonna Taylor case, the George Floyd case. Criminal justice has become at the forefront of the election, and it's important for us as citizens to know our constitutional rights. So if they are violated, we know how to attempt a proper recourse and address a deprivation of our rights. So, the Bill of Rights. It's important that we first understand the Constitution so we know where our rights come from. Within our country, the United States Constitution provides all citizens the Bill of Rights, and these are the first 10 amendments to the Constitution. The First Amendment. Many of you have heard of the First Amendment, and when you hear this, you probably think of freedom of speech. But it not only protects freedom of speech, it also protects freedom of religion, of the press, or the right of people peaceably to assemble and to petition the government for a redress of grievances. And this is particularly important, especially with the Black Lives Matter protests, the election protests. If you ever are confronted by police or you are arrested, you want to know your rights and whether you were allowed to peaceably assemble at that time. Also, it's important to know freedom of speech. Not in all instances are you allowed to say anything at a place of employment or in public. So freedom of speech is of particular importance because many people think that we can say anything we want where there are regulations on your freedom of speech. So this will become important when I talk about First Amendment and 1983 civil rights claim. Employees may be fired for political retaliation or for freedom of speech retaliation. So it's important that you understand the First Amendment. Also, the Second Amendment, that's important to the Bill of Rights, and that's the right of people to keep and bear arms, which shall not be infringed. And also a well-regulated militia being necessary for the security of a free state. The Third Amendment. This won't be of particular importance for this presentation, but I do think it's important that you know what the Third Amendment embodies. And the Constitution states, no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The Fourth Amendment, which we'll be discussing today when it comes to a 1983 civil rights claim, is very important. Within the Fourth Amendment is embodied the expectation of privacy. All of us have the right to privacy. And the Fourth Amendment explicitly states that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. And this becomes of great importance in the 1983 civil rights claim if it's related to your right of privacy in the Fourth Amendment. These type of cases are usually relevant to illegal searches or illegal seizures, unconstitutional searches or unconstitutional seizures. And I'll give you an example of some case law regarding Fourth Amendment claims and how you may prevail in those type of cases. They may involve false arrests, the use of deadly force, which can equate to a seizure, and I'll discuss how the law applies in those type of Fourth Amendment cases. The Fifth Amendment is also important. This is your right against self-incrimination. So no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So in order for the government to prosecute you for a crime, they must present it before a court, they must obtain an indictment of a grand jury which is supported by probable cause. But this does not apply to naval forces or in the militia when actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of the life or limb. That's known as the double jeopardy clause. So no individual can be prosecuted twice for the same crime that they were previously acquitted for. Nor shall anyone be compelled in any criminal case to be a witness against himself. So this is your right against self-incrimination. Nor be deprived of life, liberty, or property without due process of law. So within the Fifth Amendment, you have due process of law against the federal government, and then through the 14th Amendment, you have due process of law against state government. And last but not least, nor shall any private property be taken for public use without just compensation. And that's of particular importance in the Fifth Amendment. The Sixth Amendment. This is your right to effective assistance of counsel. Everyone who may be involved in a criminal trial or criminal prosecution has the right to effective assistance of counsel. So in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law and to be informed of the nature and cause of the accusation. So everyone has the right to confront witnesses and those who make claims against them, and to have compulsory processes for obtaining witnesses in their favor. So this is known as the Confrontation Clause within the Sixth Amendment. So if you are being prosecuted for a crime, you have the right to confront those witnesses that made allegations against you or accused you of a crime, which is very important. And last but not least, as I said, assistance of counsel for a defense in a criminal trial is a right guaranteed by the Constitution. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury should be otherwise re-examined in any court of the United States and according to the rules of common law. So if it's a civil case and the amount in controversy exceeds $20, you may have the right to a jury trial, which should be preserved by the Constitution. Then we have the Eighth Amendment, which is also important. This embodies the right against cruel and unusual punishments inflicted. This may be related to excessive bail or excessive fines that may be imposed upon a criminal defendant or a defendant in a case. And the Eighth Amendment protects your right against cruel and unusual punishments. And even for those individuals who are prisoners or were felons in the past, that right does not disappear. So even if you're a prisoner and you're in a prison cell, you still may file habeas corpus reviews or in state courts, post-conviction relief applications, which may protect a prisoner's right against cruel and unusual punishments. And then we have the Ninth Amendment, which was the enumerated clause in the Constitution, and that states certain rights shall not be construed to deny or disparage others retained by the people. And then the 10th Amendment, which is very important, gives state sovereignty to each state. So the power is not delegated to the United States by the Constitution, nor prohibited by it to the states or reserved to states respectively or to their people. So each state within our country has the right to create their own state constitutions. However, when they create these state constitutions, they cannot afford citizens less rights than the US Constitution, but they may afford more rights to the citizens of that state. So that's very important when it comes to the 10th Amendment. And as I mentioned, the 14th Amendment allows for due process against the state. And basically, in essence, the due process clause states that nor shall any state deprive any person of life, liberty, or property without due process of law. So due process against the federal government is embodied in the Fifth Amendment, and due process against state government is embodied in the Fourth Amendment. And later in this presentation, I'll discuss how you may move forward with a due process claim based upon the Fourth Amendment, a procedural and substantive due process claim. Now, it's very important to understand the history of the Civil Rights Act of 1964. Almost 10 years after Brown v. Board of Education, the Civil Rights Act of 1964 was signed into legislation by President Johnson. Martin Luther King was the catalyst behind the enaction of this legislation. It was landmark legislation that outlaws discrimination based on race, color, religion, sex, national origin, sexual orientation, and gender identity. The important components of this law are the voting rights, Title I. Then you have public accommodations for Title II. Title III is desegregation of public facilities. Title IV is desegregation of public education. Title V states what a Commission on Civil Rights should consist of. Title VI is non-discrimination in federally assisted programs. Title VII is relevant to equal employment opportunity. Title VIII is relevant to registration and voting statistics. Title IX is relevant to intervention and removal of cases. And Title X is relevant to community relations and services. This is very important, the Civil Rights Act of 1964, because in many cases, a Section 1983 civil rights claim may be accompanied by a violation of a civil rights, by a violation or the deprivation of a civil right embodied in the Civil Rights Act of 1964. Relevant case law is Brown v. Board of Education. This was one of the first cases in the United States that led to the desegregation of public schools. Relevant legislation that came after the Civil Rights Act of 1964 was the Equal Employment Opportunity Act of 1972, the Pregnancy Discrimination Act, the Civil Rights Restoration Act of 1987, the Civil Rights Act of 1991, the No Child Left Behind Act, and the Lilly Ledbetter Fair Pay Act of 2009. This is important legislation. These are federal laws that protect federal rights and also protect our constitutional rights embodied within our Constitution. I wanted to give you that brief overview of the history of the law so that the 1983 Civil Rights Law can be put into context. I also believe it is important to first understand the Constitution and the history of civil rights in our country, because knowledge is power. You never know when your rights may be violated or when you may need to protect the rights of others, such as a close relative. And this was clearly illustrated in the Breonna Taylor case, in the George Floyd case, and even in recent times in New York, in the Eric Gardner case. Now, in the Section 1983 lawsuit, you must first submit a well-pleaded complaint. So a Section 1983 lawsuit is a federal law that provides a cause of action for individuals that are deprived of a constitutional right. But one of the caveats to this law is that the wrongdoer must be acting under the color of law. So, what is the process for moving forward with these type of claims? Embodied within our US code is 42 U.S. Code, Section 1983, where you can locate the law regarding a Section 1983 civil rights claim. And this is a civil action for deprivation of rights. As I initially said, a victim must file a well-pleaded complaint. It must be supported by plausible facts, and they must have a cause of action that is recognized under the law. If you do have a cause of action and you're able to move past the complaint stage, you may also file what's known as a summary judgment motion if there are no genuine issue of material facts. When is the individual entitled to a summary judgment motion? And what is the standard of a summary judgment motion? As you see here, a party may be entitled to an entry of summary judgment in its favor where the record shows that there is no genuine issue as to any material fact and that the moving party is entitled to judgment as a matter of law. So what does this actually mean? This means in cases where there are no disputed facts between the plaintiff and the defendant, and all that needs to be applied to the case is the law, a judge may make a decision upon that case based upon the law without the parties having to go to trial. So if no genuine issue of fact exists, a party may move for summary judgment. The court noted, though, however, that substantial means disputed factual issues. So they must be substantially disputed factual issues. They must be material, having substance that's not imaginary, unreal, or apparent. Only true, solid, or real. So it cannot be hypothetical arguments. It must be actual facts that are disputed. What is also important in these type of cases? It is important that at the outset of a case, the plaintiff establish a prima facie case for a Section 1983 civil rights case for violation of his constitutional rights and the defendant's liability for such violation. How do you make such a complaint? So to make a prima facie case under Section 1983, the plaintiff must just demonstrate that a person acting under color of law deprived him of a federal right. And this may be grounded in cases involving false imprisonment or false arrest as it's related to the Fourth Amendment. Thus, in order to move forward with such an action, there are two important components that must be recognized. Thus, a plaintiff must demonstrate two essential elements to maintain a claim. They must first demonstrate that the plaintiff was deprived of a right or privileges secured by the Constitution or the laws of the United States. So if you were to move forward with such a case, you must prove that there was a violation of the Civil Rights Act of 1964 or the other federal laws outlined in the previous slides. Or you must assert that there was a violation of one of your constitutional rights, which may be embodied in the Bill of Rights or which may be embodied in the 14th Amendment, due process clause to the states. Secondly, the plaintiff must show that they were deprived of his rights by a person acting under the color of state law. So in these cases, the person must be acting on behalf of a government entity. Next, the next step is to identify the exact contours of the underlying right said to have been violated. So you must actually identify, was it a First Amendment violation? Was it a Fourth Amendment violation? Which actual constitutional right was violated and what are the contours of that right? So with that being said, I would like to give you an example of how you would proceed with a Fourth Amendment claim. Fourth Amendment claims are usually related to illegal searches or seizures of an individual. And I would like to discuss how you would move forward with this type of claim. So for a Fourth Amendment claim, the constitutionality of false or invalid arrest by state officials is governed by the Fourth Amendment rather than a due process analysis. So when an individual is illegally searched or seized by the police, the Fourth Amendment may be relevant in your analysis. So if you're a victim of these type of crimes, there's a three-step process. First, was the plaintiff seized for Fourth Amendment properties? If so, was that seizure in violation of the Fourth Amendment's prohibition against unreasonable seizures? Or was it constitutionally recognized? Finally, if there has been a Fourth Amendment violation, which of the defendants may be held liable for it? This also becomes important because with most governmental officials, they may have qualified immunity or some type of immunity that protects them against civil suits. Search and seizure and Fourth Amendment claims. What actually constitutes a seizure? A seizure, as the law indicates, is when a person is detained by means that are intentional and are applied to terminate his freedom of movement. So a seizure can occur even when an unintended person is the object of detention, so long as the means of detention are intentionally applied to that person. For example, if a police officer fires his gun at a fleeing robbery suspect, and that bullet inadvertently strikes an innocent bystander, there has been no Fourth Amendment seizure. But on the other hand, if the officer fires his gun directly at the innocent bystander, and the mistaken belief that the bystander is the robber, then a Fourth Amendment seizure has occurred. And you may go move forward with a Fourth Amendment claim. And this goes to the idea that an individual was intentionally attacked. So a seizure can be an arrest, a detention that restricts someone's freedom of movement. And in a famous case known as Tennessee v. Gardner, the use of deadly force to kill a fleeing suspect can amount to a seizure and can amount to a violation of an individual's Fourth Amendment rights. Two also important landmark cases that were decided by the Supreme Court are United States v. Hensley. In that case, the court ruled that police may conduct a Terry stop based on a flyer issued by other officers, but if the flyer has been issued in absence of a reasonable suspicion, then the stop and the objective reliance upon it violates the Fourth Amendment. So if you are stopped on a public street and the officer does perform a Terry stop, that must be supported by reasonable suspicion, or it could amount to a violation of your Fourth Amendment rights. Also in the case of Arizona v. Evans, the court held that the policies underlying the exclusionary rule do not require suppression of its evidence seized pursuant to an erroneous warrant resulting from a clerical error. But the court noted that in determining whether police officers violate the Fourth Amendment, thus the Supreme Court has made it clear that if a mistakenly issued or mistakenly executed warrant can never provide probable cause for an arrest, it may amount to a Fourth Amendment violation. So if there are situations where an invalid warrant was issued for your arrest and you were seized or arrested for that, you may still have a Fourth Amendment claim. Now, if there is no Fourth Amendment violation, you still may be able to proceed with a 1983 civil rights claim. And so the court states that where a defendant causes or permits a warrant to issue, which is invalid, but the warrant is not executed, a due process, deliberate indifference, rather than a Fourth Amendment analysis may be appropriate. So what is deliberate indifference? What is that standard? That is a stringent standard of fault that requires proof that a municipal actor disregarded a known or obvious consequence, and that may be a violation of one's rights. So a governmental entity, they may be liable for failure to train or for enacting official policies that result in a violation of an individual's constitutional rights. So if a policy or custom of a municipality caused there was a moving force behind the alleged violation of a plaintiff's rights, they may have a cause of action. Also, if a policy or custom may be established in two ways. Policy is made when a decision maker possessing final authority to establish municipal policy with respect to the actions issues as an official proclamation, policy, or etiquette. That may be defined as a policy. Or it may be situations where a course of conduct is considered to be a custom when, though not authorized by law, such practices of state officials are so permanent and well settled that they virtually constitute law. So with cases involving custom, it requires proof of knowledge and acquiescence by the decision maker. And that's important. Moreover, with these policy for failure to train claims, supervisors may be liable if they establish and maintain a policy or practice of custom which directly cause constitutional harms to citizens. If they participated in violating the plaintiff's right, directed others to do it, or as so acquiesced in the subordinates violations, it may support a failure to train / official policy claim. Thus, in order to prevail on these type of claims, a plaintiff must identify that challenged policy, attribute it to the city itself or the municipality, and show a causal link between execution of the policy and the injury suffered. Now, to wrap it up, because I do want to do a quick Q&A with the judge, it's important that you understand that within 1983 claims, you may also have due process claims. In order to assert a procedural due process claim, you must outline the protected interests that you have, and how the state deprived the plaintiff of that interest using procedures that were not constitutionally adequate. Also, in order to make it out a claim of substantive due process, a plaintiff must prove that he was deprived of protected property interests by arbitrary or capricious government action. Lastly, some relevant claims that may be associated with a Section 1980 civil rights claim. First Amendment claims. So if you were fired for free speech retaliation, you may have a Section 1983 claim. If you're fired due to political retaliation, for your affiliation with a particular political group at your job, you may have a First Amendment claim. Now, these claims involving employment are usually not relevant to at-will employment, but relevant to cases where a governmental employee can only be fired for just cause. Also, Fourth Amendment claims may be relevant to search claims, illegal searches by a governmental official, false arrest claims, use of force claims, and wrongful death claims due to deadly force. And then last but not least, the 1983 civil rights claim may also be related to 14th Amendment claims for wrongful prosecution or conviction, claims related to discrimination in the place of employment and harassment, and the violation of the equal protection of laws, which is embodied in our Constitution. So with the 14th Amendment, no state shall deprive any person of life, liberty, or property without the due process of law. So wrongful prosecutions and convictions may be claims, pretrial deprivations, employment claims for public employees, and the like. And with that being said, I did want to ask some questions to the judge so you guys can get some perspective regarding how a judge decides these type of cases and the processes they go through when deciding these type of cases. Judge Holly Gregory, how are you doing?
I'm fine. How are you and how is everyone? Good afternoon.
So we only have about 5 minutes and I want to wrap things up. So I just want to ask you a few questions to get your perspective on the civil law and the civil trial and the civil claim.
All right, I will give very succinct and short answers. Some of these issues and topics are very complicated and complex, but I'll try to give a very brief and simplistic answer as an initial introduction.
So what is actually the role of a judge in a civil trial?
All right, and as I was a judge in New Jersey, I served for over 15 years, and the role of a judge in a civil trial is to apply the law to the facts as a jury may find them. The judge also hears motions and maintains order during the course of a trial. The judge, in conjunction with the litigants, the plaintiff and the defendant, also may select a jury to hear a case. However, there are trials that do not involve a jury, and in that instance, the judge will also decide the facts and then apply the law to the facts as they find them.
So something I think is of important interest that my listeners should be aware of is that judges may be able to dismiss complaints at the outset. What may be some reasons why a complaint or a Section 1983 civil rights complaint may be dismissed?
All right, a complaint may be dismissed if it's frivolous, if it has no basis in fact, and that the litigant is aware that it's frivolous or false. A complaint may be dismissed because it fails to state a cause of action. It doesn't recite all the elements of the alleged statutory violation. And it may also be dismissed because of jurisdictional issues. It may have been filed in the wrong court.
All right, so the last question I had for you is, during the settlement process, when does that occur? Does that occur before a trial? And what actually occurs during settlement negotiations in a civil suit?
All right, briefly, I just want to describe how you come to trial. A plaintiff may file a complaint, the defendant will file an answer, and then there's a period where you gather information through a process of interrogatories where written questions are provided and written answers are provided under oath. And then next is the step of depositions, where a party may ask questions of a litigant or witnesses, and they're recorded, those answers. And then at that time, you may proceed to trial. Now, once you've gathered that information, one of the litigants may have enough information to want to sit down and have a settlement. And the judge will assist in that settlement in many cases by bringing both parties in to talk about the strengths and weaknesses of their case. And with the permission of the parties, may individually speak to the plaintiff alone and to the defendant alone to understand the basis of their case and any strategies that they may have to assist in bringing the parties closer together to a settlement. I always felt that settlement is the best resolution of a case, if that can happen.
All right, so with time being of the essence, I want to conclude this presentation and this Q&A of Judge Hala Gregory. If there's no questions from the audience, we'll wrap things up. But I think it's important that everyone is aware of their rights. The Bill of Rights, our constitutional rights, and our federal rights based upon the Civil Rights Act of 1964. So I hope this session was informational and educational to those who attended, and I look forward to presenting again and expanding upon this lecture in the coming semesters and years to come.
Thank you for having me.
You're welcome.
Everyone be safe.
Have a good
You
day.
too. Have a great day.
Have a great day. Good afternoon.
Have a great day. Thank you.
All right, have a great day.
Thank you.
Thank you. Have a good day.
You're welcome.